Hola, vamos a comenzar con la tercera.
Good morning. We are going to begin with the third panel of today. Please remain seated in the room. We have two speakers, one after the other right now. I'm going to introduce Professor Magne Strandberg of the University of Bergen in Norway. He's teacher in the University Faculty of Law, and he is in charge of civil law. And he has also worked in many expert evidence books, and he also participated in the European Evidence of Law. He's also participating in another digitalization of procedural law in Luxembourg, in the Max Planck Institute of Luxembourg. He will present us the model called UNIDROIT, and he's going to talk about the perspective of the evidence.
So, well, thanks for a very nice presentation. And first of all, Jordi and all the others here from Girona, thanks a lot for having invited me to such a very, very nice conference. Well, I've never been to Girona before, and it has been a great, great pleasure to be here. I would tend to switch the 10 degrees and rain in Bergen with 25 degrees and sun here in Girona. And of course, I will also like to join all this very, very nice academic discussions that we have had so far. Well, my topic will be a little bit different than the two others in several aspects. Firstly, my speech will take the European perspective. And secondly, my speech will more take the perspective of law than the perspective of theory. And I had this ambition to start with, to combine these new model rules of civil procedure with theories of evidence, these classical ones from Allen and Cohen and so on. I have to admit that I have to give up on that ambition. And that is not because there is something wrong with those theories. Perhaps there is something wrong with my skills, but I couldn't just make very much sense out of that combination for now, at least. So I will more or less introduce the rules, but I will concentrate on those rules which have a more theoretical interest. So I will not deal with all sorts of procedural details and so on. I will deal with the basic questions. The ELI UNIDROIT Model Rules is a result of a project which went on since 2013 till 2020. It included more than 50 researchers from all over Europe, and it ended by the official approval by the ELI and UNIDROIT in 2020. The model rules consist of 245 rules, each of them with official comments. The ELI UNIDROIT project is a follow-up of a similar ELI UNIDROIT project just before and after the millennium. That project resulted in the ELI UNIDROIT Principles of Transnational Civil Procedure Law. And the new ELI UNIDROIT project attempts to further develop those principles into more elaborated rules for the European region. And for UNIDROIT, that is quite unique. Normally, UNIDROIT deals with global projects. This is one of the first with a regional perspective, and that is perhaps also a path which UNIDROIT will stay along with for several projects later. And I also want to mention that since this great conference is in honor of Michel Tarufo, Professor Tarufo was essential for the ELI UNIDROIT rules, as was underlined yesterday very nicely. I will not go into those details again, but I just want to underline once again that Michele Tarufo has an indirect implication on the speech that I'm now going to give. Well, it doesn't get the... Am I doing something wrong with this? Perhaps this one? I think I need some technical help to just switch these slides. I'm pushing the button called Next, so I guess it's that one.
I'm sure I can help you.
Yeah. It disappeared. Perhaps you have to reload it. I've tried both now. Okay, try again. Nothing happens. There it is. Thanks a lot. Well, I'll start with just a few remarks on the project in general. I will start with the project's architecture. In charge of the entire project was a steering committee composed by representatives from ELI and UNIDROIT and chaired by former ELI President Diana Wallis and Deputy Secretary General of UNIDROIT Anna Veneziano. Most of the drafting of rules and comments were left to 9 working groups. The working groups prepared drafts which were presented, discussed and commented on in plenary sessions where all members of the project took part. Personally, I was a member of 2 working groups, the group on obligations of parties and judges and the group on appeals. After all working groups had delivered their drafts, a structure group was given the mandate to set up the entire rules with chapters, sections, parts, and so on. The structure group also made the language consistent, and they filled in certain gaps here and there. At all stages of the project, drafts were given both in English and in French, and the final version of the rules are in both languages. Some of the working groups even made translations into other languages, and attempts have been made to translate the entire set of rules into other languages. I don't know whether it has been translated into Spanish yet, but perhaps someone in the audience could update me on that later on. During the entire project, there was also several institutional observers who did not take part in the working groups, but with all the plenary sessions. That was, for instance, the Hague Convention and the EU Commission. Let us just briefly introduce the working group that delivered the rules on evidence. And the group is composed at the same structure as all the other working groups. There were 2 general reporters. That was Neil Andrews and Fernando Gascon-Inciosti from Madrid. As was also typical for most working groups, the group on evidence consisted of members from all legal families. There is a common law member, 1 French member, 1 member from the Germanic family, 1 from either Spain or Italy, 1 from Scandinavia, and 1 from the Eastern Europe. Since the project is a project of rules development, is soft law legislation, there was of course no established list of sources which we could just easily base our project on. Rather early in the project, a list of sources was agreed upon by the project members, and that list was of course amended whenever necessary. That list of sources was taken into account by all working groups. I have listed most of those sources on the slide, and I will not go through all of them. Most of you will recognize most of these types of sources. What I will do is to explain a little bit more on the goals and the methodology chosen within the project. And there was one uniform methodology applied for the entire project, which was followed by all working groups. The methodology was chosen on background of the project's basic goal or purpose. And the goal of the project was just simply to find the best possible set of procedural rules for Europe. That goal may seem obvious, but it isn't. In contrast to other projects of harmonization of law in Europe, the goal of the ELI UNIDROIT project is not to restate the current status of procedural law in European countries, and it is neither to find a sort of common core for the European traditions today. And neither was the goal to find compromises, at least not for the sake of compromises in itself. The goal was just simply to find the best rules, or more precisely, the rules which would provide the best possible practice. The best possible practice, then, that is the practice which we assumed would maximize the realization of the basic goals of civil procedure law. So, okay, that goal is quite clear, but it's very difficult to operationalize. And within most of the working groups, at least, we went on with 5 or 6 numbers of or steps that we followed. All the groups developed national reports to start with on the current status of the law for that field of law. That was the task for that working group. Thereafter, there was giving comparative analysis based on those reports. Then there was normative evaluations or suggested based on the reports. The working group would then make the first draft of the rules. They would be presented in a plenary session, and then they would be redrafted and redrafted and redrafted until we found something that all the members could agree on. I would just like to say some words of the potential impact of the rules. The ELI UNIDROIT Model Rules are, of course, non-binding law. It's so-called soft law. Or, if one would, it is suggested law. It is not formally binding law, not for states and not for individuals. Anyway, these rules, this means that these rules will not have any practical impact unless someone somewhere out in the community of judicial experts chooses to either incorporate the rules, take the rules as a starting point for development of new law, or take the rules into consideration when interpreting existing law. And in this regard, it is important to highlight that the rules are model rules, which means they are not a complete code. And the word code should not be used on this set of rules at all. The role of a model law is to set the main parts, the main structures, and the main choices for for legislation, typically. And then within that legislation, within a jurisdiction or within the EU, all the details have to be developed within based on the preferences and what would work within that jurisdiction. And in my opinion, the most important practical impact of the rules hopefully will be within national law, within the law of each jurisdiction. And there have been some attempts already to implement some of those rules in a few European countries. My own country is one of them, where some of the rules on appeals have been suggested as a part of a recent law reform. Finally, the model rules will probably have a significant influence on academic discussions, at least within the pure legal discussions. And I guess it would take some of the rules comparable to the other UNIDROIT rules within substantive law. And these new model rules may work as a kind of a common frame of reference for quite many comparative analyses of law, which will be easier based on these model rules than if one has to start with all the primary sources of each country. So that was my introduction to the project in general and the structure of the project. I will now turn to some of the rules on evidence, or some of the general principles which are especially important for the rules on evidence. I will start with the roles of the parties and the principle of cooperation. And these are the general rules concerning the roles of the parties. And in the model rules, the divisions of tasks, competences, and roles are covered by general principles, but those principles are of special importance to gathering of evidence. And traditionally within Europe, the roles of judges and parties in civil proceedings have been dealt with on background of a dichotomy between adversarial and inquisitorial modes of proceedings. That dichotomy has caused trouble for previous projects aiming to harmonize civil procedure law in Europe. While some jurisdictions are more or less consequently adversarial, others are at least apparently and on paper, and to some degree in reality as well, inquisitorial and leave some ex officio taking of evidence powers to judges. And according to the official comments to the model rules, the principle of cooperation is intended to kind of building a bridge between the inquisitorial and the adversarial mode of procedural styles. And the basic and also most general expression of the principle of cooperation is found already in Rule 2. It says, parties, the lawyers, and the court must cooperate to promote a fair, efficient, and speedy resolution of the dispute. And the principle of cooperation is a very important feature of the model rules. The prominent rule of that principle is seen by the very general formulation of the principle and by the principle being the second rule of the entire model. The only rule before this one concerns the scope of application of the rule. So the principle of cooperation is the very first rule on the substance of proceedings. So the model rules do not start with the roles of judges or courts, neither with the parties' freedoms of autonomy. It starts with a cooperation between all of them. And within the model rules, this principle of cooperation is not only a general principle, it also is found in more detailed versions throughout the entire model. And the principle of cooperation is also a general principle, which means that it applies as a duty to cooperate for all procedural steps taken by all parties at all stages of proceedings. It even applies to the phase before formal commencement. Guess I have some water. Well, sorry, that helped. Okay. We have seen the Rule 2, the principle of cooperation, and noted the role of the parties within that principle of cooperation. Well, apparently, the general principle of cooperation between parties and judges may suggest that all evidence is to be produced and presented with all these actors involved. However, all issues concerning facts and evidence are first and foremost left to the parties, which you will see in Rule 3, litera C and E, first and foremost C. And in accordance with most European jurisdictions, both today and historically, the later Rule 24 makes clear that it is for the parties to allege relevant facts. The judge cannot consider any other facts, and the rules on evidence will apply, of course, only to material facts which the parties disagree on. Admitted or non-challenged facts do not need positive evidence, which is mentioned in Rule 88. In accordance with most European jurisdictions, both today and historically, Rule 25 makes clear that each party is required to prove all the relevant facts supporting its case. Parties must offer evidence supporting the factual contentions. So, the main role of production and presenting evidence are still left to the parties. So therefore, the basic model, of course, is the well-known adversarialism. But it is not just any kind of adversarialism. It is adversarialism which leaves the competence and the task to the parties. But the parties has a duty to act in good faith and to avoid procedural abuse when dealing with a court and other parties. See Rule 3, litera E. And that is the important aspect of the principle of cooperation. So it is adversarialism, but it is a soft-style adversarialism. It is not a sort of adversarialism which, where the parties maintain some sort of unlimited freedoms. Parties, according to these rules, are no longer entitled to present only evidence which are in his or her favor. He is not free to withhold such evidence, and he is not entitled to, for instance, destroy evidence which a party should have known the relevance of. So, by the inclusion of the principle of cooperation, which is especially important compared to some of these European traditions, the old Roman sentence saying that a party to litigation is not required to put weapons into the hands of their opponents, that sentence is just simply history. A party may be obliged to put weapons in hands of his opponents. That is an important element of cooperation, according to these rules. Well, that was the parties. What about the judge or the court? Well, while it is for the parties to allege facts and present evidence, it is, of course, for the parties to decide on the factual matters on basis of the evidence presented by the parties. However, the role of the judge within the model rules go far beyond the obligation to decide the case. Most importantly, the judge is under an ongoing duty to provide active case management. See, for instance, Rule 4. The court's case management powers and duties are concretized in very many later provisions. One of the main elements of such management is to monitor whether the parties have acted in accordance with the procedural duty, in accordance with a duty to cooperate in good faith. And another main goal of active case management is to ensure the proportionality of proceedings. See Rule 5. And within the model rules, the judge are also left with some competences to initiate taking of evidence on his own motion. Firstly, Rule 92 second subsections provides a judge with a power to suggest new evidence produced by a party. Such a power exists in many, but far from all, European jurisdictions. It is well known in Germany, in Sweden, in Norway, for instance, as a part of this so-called power to substantive guidance to the parties. While such a power assumes some sort of judge activity, it is not really an exception from the principles of parties' autonomy, since it is still for the parties to choose whether the advice from the judge is to be followed. The second exception, or the second power for the judge to include new evidence is found in Rule 25, third subsection, the last sentence. Exceptionally, it may take evidence on its own motion. Evidence taken ex officio is a clear deviation from the principle of parties' autonomy. But as is underlined in the rule, the power shall be used only exceptionally. So the mere absence of certain evidence is not enough here. There must be a particularly good reason for a judge to take evidence on his own motion. One such reason could be if the case concerns important welfare interest for a party, or if a party lacks the resources to produce the evidence. Another reason could be if the evidential value of the evidence would be higher if the evidence is produced or taken by the judge instead of by one of the parties. Well, that was the role of the parties and of the judge. I'm now going to perhaps the most practically important changes or developments suggested by the model rules. And that is the rules which are suggested for the access to evidence and then access to evidence between the parties. And the problem of access to evidence is, of course, a universal one, or at least a problem carrying the same features in most countries which base their system on parties' presentation of evidence. Such a system will run a serious problem whenever a party lacks access to potentially important evidence. And that problem arises both when only the opposite parties have access to the evidence and if a third party or a non-party have access to that evidence. Within the European law today, there are some rules which solves some of these access to evidence problems. Both the 1994 TRIPS agreement, the 2004 IP directive and the 2014 competition law directive require states to establish rules on access to evidence. Therefore, of course, such rules exist in Europe today. They are established in all member states, but only as required, at least, by the EU for intellectual property rights and for damages following from competition law infringements. And for most other sorts of cases, the law on access to evidence depend on national traditions. So, what does these national traditions look like? Well, this is one of the remarkable contrasts within comparative civil procedure law today. The rights to have access to another person's evidence is extremely different in different legal families. Within the common law tradition, the guiding principle has been to open up, to bring cards on the table, and to provide all parties with a right to access evidence, both in the position of the opposite party and in position of any third party. And the history of that tradition goes very long back in time. For instance, is one of the leading cases, the Peruviano guano case from 1882. And the tradition of open and broad access to evidence was further elaborated in the US when the 1938 FRCP was established in the US. As a part of the Roosevelt New Deal legislation, very broad right of access to evidence was included in the rules of discovery. The requirement of relevance was further relaxed, and an innovative set of new discovery devices, at least some of them were new, were introduced at that time. Later, the US discovery rules has been a little bit more limited and narrowed, but the essence of the rules are still very much alike, the very open and general rules decided in 1938. So the general rule in US is that one shall have access to any evidence that is relevant and non-privileged. That is the starting point also in the other common law countries, for instance in England and Wales. The tradition in England has always been a little bit more limited on these issues, and that has been further developed by the Wolf reform during the 1990s, where the rules of disclosure came instead of the older rules of discovery. But in a comparative perspective, also England and Wales are characterized by a general rule saying that a party shall have access in some way or another to any relevant and non-privileged evidence, as long as it is proportionate to the case. Well, that was common law. What about the Germanic states? What about Germany? Well, it is quite the complete opposite. The historic tradition in Germany is to regard the access to evidence questions as matters of substantive law. Therefore, one would not in Germany have a right to access another party's evidence unless that is grounded in, for instance, a contract, or if you were the owner of that piece of evidence. And in modern German law, there has become some exceptions to this rule. There have been established some rules on access to evidence, where a party, according to the rules in ZPO 142 to 144, may claim or request access to very limited and very narrowly specified pieces of evidence in the opposite party's possession. But that is not a genuine right. It depends on power by the judge, and it is for the judge either to say yes or no to such a request. So German law and common law is here at the straight opposite kind of sides of the story here. And of course there are very many middle-way solutions found in many European countries today. In the Scandinavian countries, in Sweden and Norway, Denmark, there are rules on access to evidence, and you will in principle have a right to access evidence, but on certain conditions. And that is the law also in Holland, for instance, in the Netherlands. So, a massive task then for the ELI UNIDROIT project was to find or suggest some sort of a solution to this very practical question. And I know that the working group worked intensely on these matters, and the rule they suggested are quite detailed, elaborate, and they are a genuine compromise. Well, the starting point for these rules is that there is a right to have access to evidence. That is found in the Rule 100, which says, as a general rule, each party should have access to all forms of relevant and non-privileged evidence. A very important part of this rule is all forms of, which of course includes all sources of evidence. And even that starting point is very different from the German starting point today. At the same time, in the comments to the rules, the commentators rigorously underlines that the model rules are particularly intended to ensure that access to evidence is secured in a manner that is very different from US-style discovery. So the model rules have taken the starting point from common law, while at the same time saying that we shall not have the practice from common law, at least not from the US. And the important question then is, okay, how shall we find that balance? And the balance is found, of course, in the other rules within this chapter. And firstly, a person who claims access to evidence from another party or a third party has to request that as an application to the court. It is not an automatic right. It is a right which you may have based on a request. And what I will underline here is that even though such applications could apply or could happen quite often, of course, the primary path of the evidentiary systems in most European countries, that is self-help. If a party may find evidence without involving the opposite party, then he is supposed to go on with self-help unless some sort of epistemic or moral reason suggests otherwise. That is also the reason why there shall be a request and an application in those cases where you would have a court order. And on the other side, a party who is aware of relevant evidence, which he or she has a reason to believe that the opponent is not aware of, may have an obligation to inform his opponent on the existence of that evidence. According to the principle of cooperation, a party should give the opposite party access to evidence in this situation, or at least inform of the evidence on a voluntary basis and on his own initiative. So therefore, these applications and the formal parts of these rules, they are intended to be used when the parties cannot agree on the access to evidence matters between them. So, the criteria for the judge to apply when such an application is on his board is found in the Rule 102. I will not go in details on this. I will just very briefly mention these requirements. And it is, of course, these requirements and the existence of them which is really the balancing between the German approach to this and the common law approach. So before a judge order will be succeeded here, a party has to identify the specific sort of evidence, or at least identified categories of evidence by reference to the nature, content, or date. So you cannot, as in the US, just say that, okay, I would like to have anything that is in the possession of the other party. The so-called fishing expeditions of US law is prohibited under these model rules. And secondly, there are some further requirements concerning both the merits of the substantive claim in the case. The claim has to be plausible, and the requested evidence must be necessary for the proof or the proposed proof, and it is a requirement that the applicant cannot otherwise gain access to this evidence without the court's assistance. And finally, the application must be reasonable and proportionate. And the last requirement is found also in English law, and also in modern US law, I think. The timing of these applications are dealt with in Rule 106, and the important matter here is quite easy. A party may apply for access to evidence at any stage of proceedings. The normal way to proceed would be to apply for such access during the preparatory stage, that is after commencement and before trial, but a party may also claim for access to evidence during trial. And a party may also request for access to evidence before commencement as a so-called pre-commencement duty of the opposite party. But there are some additional requirements for such pre-commencement access to evidence order. And firstly, a pre-commencement access to evidence order could be combined with a requirement of initiating proceedings within a given time limit. And secondly, a party who claims for pre-commencement access to evidence has to indicate with sufficient precision all elements necessary to enable the court to identify the claim for relief which the party has intended to make. I will just say a few words on the implementation of these court orders. These are very practically important matters, both within common law and within my own jurisdiction as well. And it has to do with the how and whens of the access to evidence in practice. I will not go into details on this, but I will just stress that the details are very important on these matters. And I would also like to comment on, after the meetings yesterday, that one of the quite difficult tasks that a judge may be met with here is a problem found in e-discovery in US and the other common law countries, and that is this one. Whenever access to evidence are granted for massive amounts of digitally stored information, which may happen under these model rules as well, there is a need for a so-called review process of that information in order to find the evidence which are relevant and non-privileged. And in the common law countries, techniques based on machine learning and other sorts of artificial intelligence have actually been used for these purposes during the last years. On the other side, such techniques are not always the best possible option for these cases. And there's quite a lot of case law on this, both in US and in England and in Ireland, where the judge has to make some sort of a choice between manually review of tons of documents or technologically assisted review. And that choice is quite difficult because there are pros and cons for each of these techniques. I will just very briefly say something about the non-compliance with access. A few words on the non-compliance with access orders. And that is another key characteristic of the Anglo-American rules, is that there are quite severe sanctions connected to breach of access to evidence orders or other kind of breaches of discovery rules. That is not found in not the European countries that I am aware of, at least. It may be in some which I'm not able to follow very closely. But the main tradition in my country, for instance, is to say that, okay, if there is a breach of such an order, that will be taken care of within the evaluation of the evidence, for instance. Or a fact may be regarded as admitted. And that solution is found also within the model rules. Rule 110, A and B, makes clear that a person who is unwilling to disclose his evidence may be regarded to have admitted the fact in the case and thereby will just simply lose the case, at least on this specific matter. And the rules also opens up for, in litera C, a kind of a penalty sanctions per day, which is another kind of sanction which is not known in my home jurisdiction and which is not known in most European jurisdictions, I think. Okay, that was the access to evidence, and that is, in my view, the most important new suggestions within these rules. I will just at the end of my speech now, very briefly take up some other aspects that I know that has been very much discussed, of course, within academic circles. And the first of them is the burden of proof. The regulation of that one in the model rules is very simple. It just simply says that substantive law determines the burden of proof. That is the classic German style of approaching the burden of proof. It is not the way which is normally, that is not a regular way to approach the burden of proof in Scandinavia, for instance, where in Denmark, for instance, one would say that the party who could have secured the evidence will have the burden of proof. That is not the standard solution within the model rules, which just simply says that it is a matter of substantive law. Well, I will just underline here that it is model rules, and model rules here means that this is the suggested main rule. There may, of course, be very many nuances and exceptions to this rule. Now to another hot topic, perhaps the most discussed matter of evidence law during the last couple of decades, the matter of the standard of evidence. My own favorite topic from a theoretical point of view, at least. This is also one of those areas of European evidence law where there are tremendous differences, at least on paper, perhaps also in practice, between the legal families in Europe. And here in the common law tradition, of course, a very low standard of evidence applies in civil cases. The normal standard, at least, and applied in nearly all cases in US, and in all cases, with a very, very few exceptions in the UK, is the rule saying that there has to be a preponderance of the evidence or a more probable than not standard. I will not go into the details on all this. We could have discussed this for hours, of course. But the main message here on the comparatively is just simply to recognize the quite low standard, the very low standard of the common law countries. Outside the common law countries, there is not very many countries who has this more probable than not standard as the general rule. And one of a very few is my own country, Norway. We have that as the general rule, and it was developed independent, I think, of the common law traditions back in the 1940s and 50s. Well, okay, the Germanic law, once again, has a quite different standard. The Germanic standard, at least on paper, and I think also in practice, at least to a certain extent, and perhaps not as high as suggested in the books, but still, within the books, the classical way to approach this in Germany is to say that we need full proof. The Germans should be fully convinced. Of course, that is impossible, but at least in Germany, they still insist that the judge shall be convinced that there is a high probability for the fact which is presented by the party who carries the burden of proof. And the link to the burden of proof theories are very, very, very important here within the German theories. Within other countries, we see a lot of other solutions to this problem. In Denmark, for instance, there are rules on the standard of evidence, but they are fragmented. You won't find a general rule for the entire civil proceedings. You will find one rule in contract law, another rule in tort law, and then within tort law there is one rule for negligence, another one for strict liability, and so on and so on. Well, it works in Denmark, apparently. It's a bit complicated, but it seems to work. And then in French law and in Dutch law, as far as I have understood at least, in general, the standard of evidence in civil cases is not fully legally regulated. It is still, to some degree at least, regarded as a part of the free evaluation of evidence, which also is the historical approach in most countries, in the Scandinavian countries and in Germany as well. And that is still, as far as I have understood, there is still some elements of that left in France and in Holland. Well, okay, this as well, I guess, is a practically important matter, which the ELI UNIDROIT rules, of course, have dealt with. The rule on this matter is far from as nuanced and developed as the rules on access to evidence. The Rule 87 on the standard of evidence, it gives some sort of a solution, but it's not very detailed. And it just simply says that a contested issue of fact is proven when the court is reasonably convinced of its truth. I think one shall regard that rule as a compromise. And firstly, it is a compromise between jurisdictions which have rules on the standard of evidence and jurisdictions which do not. Rule 87, it is a genuine rule, of course. It is binding for the judge, but the rule leaves a bit of flexibility and leeway to the judge. And secondly, I guess it is some sort of a compromise between the Anglo-American tradition and the German tradition. The standard in Rule 87 is clearly higher than the Anglo-American one, but it does not require the formally very high German standard. And I would also stress, Rule 87 is, of course, not intended to be the entire solution for the entire matters of standards of evidence within civil procedure law. This is a model. This is model rules, and it is supposed to be a starting point, a main rule, on which I guess all members of this project would recognize that there need to be a lot of exceptions and a lot of nuances within each jurisdiction. Just finally, I would also like to stress that even though there is a general rule on the standard of evidence in the model rules, I personally would say that a new way, at least for some countries, to address the standard of evidence issue, which would be quite coherent within the model rules, is to follow the principle of cooperation. And to say that if a party could have secured evidence, could have produced evidence, which he should have produced, if he acted in good faith and so on, well, perhaps the standard of evidence should be used as some sort of a sanction against that party. That is an opportunity, at least, and I would leave those matters to the discussion. That was all I had. Thank you.
Thank you, Professor Strandberg. We are going to start with the debate. Pidió la palabra.
Jordi Ferrer asked for the floor. Please go ahead.
Muchísimas gracias, Magne.
Thank you so much for your presentation. I found it really interesting. I'd like to make a couple of comments here, and maybe also a critical reflection about the final part, when you were talking about the standards of proof. You have made two comments. There is something which I think is missing here in the rules. I think there is not an explicit mention of which is the goal of the proof of the evidence in the judiciary procedure. I mean, if we do not know exactly which is the goal, the objective, the parties and the judge, they have to cooperate for what exactly? In order to get what? To achieve what? If we don't have a specific goal, we do not either how to apply the proportionality principle. Proportionality regarding what? There's something missing here, I think. And I think that depending on taking into account all the rules, at the end, we could maybe think that the goal here is just to find the truth, to say it somehow. So, for instance, when you are talking about the standards of proof, we think that we are just trying to find the truth. So that's what I would understand. But maybe we could discuss a little bit further about this, because you have never said it explicitly, and I think it doesn't appear here as far as I see. And I think this is a gap. There is something else which I think is quite important and has an important impact regarding the expansion in Latin American and in Latin Europe of the dynamic burden of proof. So this reverse of the burden of the proof in the procedure, it has to do with trying to find a mechanism where you can access the proof. What do I mean here? I mean that there is a nuanced way of discovery here, and I think this is a very good option. So, anyway, there is a main issue here which appears at the end. So we have said that there's a free way to assess the proof. Okay, but then at the end we have a standard of proof which leads us again to a subjective conception, a persuasive conception of the proof. So here you were talking about rule number 82, if I'm right, and you were saying that a fact is proved whenever the court is reasonably convinced that it is true. Yes, but you are not saying that there is a proof of truth or there is enough accreditation of proof, etc. You are saying that the court has to be convinced, and there is a subjective element here, because even if we add the term reasonable, and you may understand reasonable in different ways, at the end of the day, there's such a degree of subjectivity here, because what happens if the court is not convinced? Then it's not proved. So it doesn't matter, maybe you can have a lot of evidence, but they have to be convinced. So I think that this rule obliges two things. On one hand, they have to be convinced, and at the same time, this has to be reasonable. But what happens if one of those two criteria are not there? Then it's not proved? Well, I think that it's important to see this rule, because you are talking here about necessary conditions, prerequisites, which are really important. And I think this is not admissible if we are talking about a rational conception of the proof. Something which is objective or rational cannot depend on something so subjective of the judge or the juror or myself or my mother or whoever we think about it. It has to be something more objective from a conceptual point of view. So I don't agree with you about that. And you are saying that this Article 82, Rule 82, is higher than the preponderance of evidence, as you were saying, and is lower than the German one, that it's something in between. Why do you say that? Because you are talking about being reasonably convinced about the truth. Why is this higher than the preponderance of proof? This means that if there is a hypothesis which is in theory more truthful than another, I cannot be convinced about something different? Why not? It should seem rational that I might adopt as my belief the hypothesis which is more probably true. If I do that, then a hypothesis which is preponderant, it will be something that I believe, and then it's reasonable to believe that this is true, and then this will become true. So I don't think this standard is really higher than what you were saying before about the preponderance of proof. But everything depends, again, on the different requirements I have put to myself to convince myself myself. So again, we are going to a subjective thing. I can think that Jordi can be have very high standards, but maybe you have lower standards, so then it will really depend on who's there judging, and the result will be really different. Or I can be more exigent myself for this case, but less for the other one there. So it's too subjective. There are bias, there are prejudice here, there are, I don't know, my background, something like that. So if we include this subjective part, we will always be talking about subjective, and this is not compatible with determining the standard of proof. Thanks so much.
Oh, well, that was nearly my entire speech. Well, but thanks a lot, Jordi, for very, very nice questions, and, well, of course, very sharply put questions. I will try to answer, well, it wasn't really a question, it was comments and your opinions, and well, that is very fine. I will try to get into most of these aspects that you dealt with, and firstly, concerning the goal of the proceedings, that is partly dealt with in the preface of the rules, but of course it is quite short, and it is nothing similar to what we would do within national law. At least in my country, we would spend quite some pages in the preparatory works to explain what we would like to achieve with such rules. Within model rules, it needs to be more comprehended, and the goal of the rules is to have a fair opportunity for all citizens to use the courts as mechanisms for securing their substantive rights. And I also have to say that I have wondered a little bit about the role of truth within all this, and it is not specifically mentioned as one of the goals of this system at all. But I agree with what I think you mentioned here, Jordi, that the goal of truth necessarily has to be one of the goals at least, as how the goals are, or the rules or the principles are formulated. Something like the corporations, for instance. What is the meaning of corporation if it isn't for finding the truth in some way or another? It is the very point of it is, of course, to deter parties from destroying evidence and sending the message to future parties that, okay, if you do so, you will be sanctioned by one way or another. That is as far as I have thought through this, that is the mechanism that one hopes to achieve by the principle of cooperation. And so the parties and the judge are supposed to cooperate on all matters of the proceedings, but it is, of course, it has been fronted perhaps a little bit more than necessary within the rules because I would say it is newer and a little bit more trendy, perhaps, than the classical principles. It's still important, of course, in my opinion at least, these matters of cooperation, but it is perhaps stressed a little bit too much, and of course it is still for the parties to do self-help, to be autonomous persons within private litigation, of course. It is not meant to be some sort of overall kind of enforced cooperation on all matters in practice, even though in principle it is a generalized principles, which may in extraordinary circumstances be breached by all sorts of procedural steps. Well, and for the proportionality test, that is quite expressly dealt with in the rules 6, 7, 8, I think, and the proportionality has to do with the amount of the claim compared to the costs of the case. So it is the classical concept of proportionality found in England and Wales, which has found a way into the rules, which we also have in Norway, for instance. So it is not only in England and Wales. Then to the matters of the burden of proof as a kind of a instrument for getting access to evidence. Yeah, I completely agree on that one. That is a possible path. And that is also a part of the, which I couldn't go into because it's quite complex, but that is also a part of the German system. And it's both the so-called Beweislast in Germany and also the so-called Darlegungslast, which means that a party who could not have access to evidence can just bring about a general proposition of the facts in the case, and then it is for the opposite party who should be able to take out the details, even though he is the defendant in the case, to explain what happens and so on. For instance, in a medical liability case. Or a product liability case, where it is the producer, of course, who has the knowledge of what happens. So I totally agree on that one, and it was just for the just because of the time limits that I couldn't go into that one. Concerning the standard of proof, well, I agree on most you say on that aspect as well, personally, although my personal opinions have not been followed in the rules on all aspects, of course, as it is for all the other members of the project. And I totally agree on the formulation of the standard of evidence, formulating standards of evidence in terms of belief and so on, that turns an unnecessary subjectivism into the rules. In my opinion, it should be formulated more like degrees of evidential support. For instance, just simply saying that, okay, the preponderance of the evidence, or what's the American word, the clear and whatever evidence. Yeah, thank you. So that would be a better way to pronounce these rules. On the other hand, the standard of evidence was not the rule that was most dealt with by the working group. They prioritized the access to evidence before the standard of evidence on these points. And I think personally that was the correct decision, because it's very difficult within a model law to find formulations of the standard of evidence that would be acceptable for all the European states. Well, that was a long answer. Sorry.
Thank you. I'm going to alternate one written question with one oral question.
In Spanish?
Yes, in Spanish. Muchos autores señalan.
There are many authors who signal in general terms that lawyers sometimes make it difficult to access the truth when this is against the interests of the client. So they are just trying to rebuttal some arguments which are rational on their advantage. So how can we make this compatible with the principle of cooperation you were talking about?
Okay. I don't know whether I understood correctly, but what I think it is the same question, but I've heard some ways before, and it's a classical situation where the lawyer has some suspicion that the client has some more evidence, and the evidence is positive for the opposite party, and the lawyer, of course, has some sort of loyalty towards his client, and at the same time, both the lawyer and the party is under this duty of cooperation. I guess that was the question, and well, my answer to that one is that one shall follow the principle of cooperation, and the lawyer in such a situation should have a duty to make sure that his client acts in accordance with his procedural obligations. So if a lawyer is aware of evidence which a party tends to just cut away, well, then both the lawyer and the party has a duty towards the court and the opposite party, well, just to get that evidence on the table. And that is an element of the principle of cooperation.
Thank you. Now, Professor Paul Roberts.
Hello, thank you. I thought I was just writing a question, actually, but I can speak it just as easily. Thanks so much for informing us about not only supranational regulation and evidence at the European level, which is now certainly a subject that's not as well known to most scholars as the national level, but also information about civil procedure, because certainly in my jurisdiction, most of the experts in evidence law, like me, come from a criminal law background. And hearing more about civil procedure is enormously useful and informative for us. I want to say a little bit about this idea of cooperation, which has already come up in the discussion. Firstly, just to reinforce your remarks about the progress of that idea in England and Wales. It's fascinating to see, you know, perhaps the influence of an English model in the civil procedure rules. Indeed, in England and Wales, this idea of mutual cooperation allied with judicial case management, active, proactive judicial case management, is indeed making significant inroads into criminal litigation as well as into civil procedure. And this clearly challenges classical adversarial models of party-run process. It goes back also to the discussion earlier this morning about experts, Professor Mnookin and Carmen Vasquez talking about English models there. I think Americans here might be surprised to learn the extent to which party cooperation and judicial case management has made progress in England and Wales, traditionally an adversarial system, in the direction of what you might call crudely a more inquisitorial approach associated with civilian jurisdictions. Okay, so this raises all kinds of questions. From my perspective, these developments are not comprehensively good or comprehensively bad. They're certainly new and they're certainly different, and they raise challenges of all kinds. So I want to ask you more specifically about a particular issue that you raised in your very illuminating discourse on the detail of the civil procedure rules, the model procedure rules that you've been discussing. And this concerns the power of the courts and of the parties, indeed, to demand information from the other side. Now, the obvious thing that occurs to me as a criminal lawyer is privilege against self-incrimination. So really my question is in two parts. First of all, why doesn't that breach the privilege against self-incrimination? And secondly, and I'm perhaps anticipating the answer, is it the case that there's built into the civil procedure rules that you've been discussing some kind of what we call use immunity? Are you familiar, you know the idea of use immunity? Is that the way you've got around the problem? That's how we've solved the problem in England and Wales. Thank you.
Well, yeah, the short answer is that, and well, as you could, firstly, very many thanks for your introduction to the rules in England and Wales. My great friend and colleague John Robbie has introduced me to these traditions in beforehand, and I'm very, very welcome to hear those aspects of the law in England and Wales, even here in the plenary session. And well, concerning your two questions, the matter of self-incrimination, if I understood correctly, you are asking whether there is some sort of an exception, both for the access to evidence orders, for not having a party to incriminate himself, and that was the question, wasn't it? Yeah. Yeah, and yeah, there is a rule on that one. I cannot find it straight away, but there are one rule within these model rules which has to do with privileges. And there is one in the access to evidence chapter and one in the presentation of evidence chapter. And I think that the self-incrimination is mentioned as one of these alternatives. If it is not, it will, I guess it will go under one of the general clauses. But I would personally, I would say, well, of course there should be some sort of a self-incrimination limits to the access to evidence rules and to other parts of evidence law as well. Concerning the immunity and the use of the disclosed disclosed materials. There is also a rule in the matters concerning, I think I should find that quite quickly. That is, well, for instance, there is a Rule 104 on sanctions for breach of confidentiality. That is some of these matters that you ask for, isn't it? And yeah, and that is also developed in Rule 103, which gives the requirement for confidentiality for evidence that has been disclosed during proceedings. So yeah, very short and briefly.
And now, written question in English. Arguably, the success of any set of procedural rules or practices depends on its use by influential courts. Has it been discussed within the steering committee or any working group the possibility of expanding access to the European Court of Justice or the European Court of Human Rights, and perhaps extending its jurisdiction as a way to developing core principles of European civil procedure?
Could I see that?
Yes.
Well, okay. I'm not quite sure whether the steering committee has had any debates with the C or the EU or with the European Courts of Human Rights on these issues. And I was not in the steering committee, of course, otherwise I would have known. Not all of those aspects on the, more diplomatic issues are known for all the members, I guess. So I don't know. I would guess that there has not been such meetings, but I don't know. And it has, as far as I have seen, not been a part of the project to suggest rules for the development of the EU law and the court and the rules for the European Court as such. And that has partly to do with the project itself. It is not an EU project. It is a European project. The suggested rules may, of course, be taken up by the EU later on as some sort of a recommendation, perhaps. But the project as such is not narrowed to the EU. So it's still relevant for England and Wales, and also for us in Norway, and also for those countries that are outside both the EEA, the EFTA, and the EU. Well, I don't know whether I answered the intention behind the question, but I don't know.
Thank you. And now, Alejo Giles.
Muchas gracias, profesor.
Thank you so much, Professor. I would like to make a brief comment. I have the feeling that when the standard of proof and the assessment of proof is being regulated, there is an opportunity which is missed here, because we could go one step forward to guarantee the rationality of proven facts. And I think that there is an opportunity to create procedural rules. Here we can see there is some gap. You were mentioning some examples at the beginning, the Professor Allen you were mentioning. And I think that theory needs to be useful for those who have to amend things or to make reforms or to create these rules. And there is something which should be done by the theory, which is to create an archetype, a paradigm of evidence reasoning. Because otherwise we will just have some judges who are deciding one thing here and another thing over there, and judges can make mistakes. So what we should do is to establish how evidence reasoning is rational. What do we need in order to get this rational system? And I think two inputs might be useful for that. First of all, we have our best epistemology here. What can we find here? Which is the best reasoning? Which is the best way to achieve truth? I mean, if we accept that truth is the end goal here. And the second thing, what can we see from empirical research? Which are the limitations from a cognitive point of view of people? We are going to give a task to some persons, and they are the ones who are going to decide about the evidence, jurors, judges, etc. So I think this is something to be dealt with within the theory of law. So if we have someone who is sitting there and is trying to reform a procedural law or to establish some model rules or something, they should have these inputs. And I think we should have these paradigms or these ideas of reasoning, and maybe we shouldn't pay that much attention to what happens with judges over here or judges over there. Thank you so much.
Oh, yeah. Well, thanks for some very interesting inputs. Well, the reason why the model rules don't go more extensively into these matters, I think there are several reasons for that. Firstly, it was the timetable. We had enough to do in the first place, and going into matters which really required theories and evidence and so on, which also I don't think was familiar for very many of the members of all the working groups and so on. I think that would just have taken too much time within this project. I guess also, I was not a member of this working group, but I guess also they troubled finding some more substantial way to write this standard of evidence in a way that was acceptable for the bigger nations, for Germany, for France, and for England, and so on. So I think they had enough to struggle with just to find a sentence to set on the paper. And it is also, by the way, the very same formulation which is found in the ELI transnational rules from back in 2004. So I don't think that the matters on the standard of evidence was very high prioritized within this project. When concerning the more prospective parts of your question of whether there should have been developed some more perhaps norms for evidence in Europe, well, I think that could be a good idea. I mean, we have got now within these model rules something similar to the American federal rules of civil procedure. Perhaps it is time to find European parallels to the federal rules of evidence from the US, which we don't have today. Those rules that I have presented do not go into the more material aspects of evidence law. And that could be a good suggestion. And I would also say, I dealt a lot with theories of evidence some 10 years ago. And I have dealt with comparative civil procedure law within Europe for the last 10 years. And what I'm missing now is more theories of evidence which are genuinely European. And that could be some sort of a project to get up. There are some, of course, but there's not very many. And not all of the theories arising from the US are easily applicable to our systems in Europe. And those theories that has been developed in specific European countries is not always easy to apply in other European countries. So a sort of evidential theory with a genuine European perspective would have been interesting. Perhaps it exists already. Without my knowledge, I haven't been very updated for the last years, but I would be very pleased to hear about it if there was any such projects going on.
Gracias. Antes de los merecidos aplausos, quería...
Thank you so much. Before the round of applause, I would like to tell you that we are going to take a family picture in the hall where we were having the coffee break before. So just after we finish here, please let's go there. So we are going to take a family picture. Thank you.